We're disappointed in the decision, obviously. We knew this was going to be a difficult case to win, but it was the right thing to do. 375,000 people thought they were going to get something out of that 2006 amendment, and they didn't. And we did what we could to bring a case that presented the issues so that the Supreme Court could decide how far did the legislature need to go. I think there's a long and appropriate history of the courts being deferential to the legislature in areas that are appropriately legislative. In this instance, I think we made an argument, and a credible argument, that in a circumstance like this, the legislature should do more and should be required to justify what it has done if it does something that deprives the people of something they thought they were going to get. The court really, I think, disagreed fundamentally with that view of the case and said, no, we're only going to do this if you can show that what they've done was irrational or not legitimate in some way. And even if it were, and I guess to pick up your point, even if it were unwise, if we would have done something different or you would have done something different, that's not enough. It has to be illegitimate or irrational. I think that's the standard they used, and that's the standard they applied. I think there was a political judgment made by those who were sponsoring the plan that the latest possible rollout would blunt as much criticism as possible. Because I think there are people who live in a lot of towns throughout the state who were very, very surprised that they weren't put in their own legislative district. And I think if they had realized it early and had been able to ramp up political pressure on their own representatives, there may have been some other decisions made. But I think a strategic decision made by those who were backing this plan not to do that probably blunted a lot of that criticism.